The West was settled long before the Forest Service and BLM land management existed. Congress encouraged the establishment of ranches throughout the West by passing laws to grant and confirm specific property rights to settlers while reserving other interests to the government. Okay, this whole split estate concept. When they recognized custom, state and territorial law and custom and rules of the court under the Act of 1866, there were certain laws that went along with, for example, stock water rights. What was the custom? Okay, Congress had recognized this. They had validated it with the Act of 1866. And in 1978, again, that is not ancient law. That's fairly modern law, 1978. In a case called U.S. versus New Mexico, the United States Supreme Court unanimously ruled that ranchers own the stock water rights within forest reserves, national forests. That's a case you can look up. I've got the citation for it. You know, I don't ask you to accept anything that I say. That's why I put this into my dissertation. I put every citation for every assertion so you can go to these laws and read them yourself. Now you're starting to scratch your head and you're saying, how can this be? You know, I've always been told that the government owns everything out there. This is their property. Okay, so maybe I'll be able to shine some light on that by answering this question. What are public lands and where did they come from? And Cliff covered a lot of this earlier, talking about the history. In the early days of the United States, there were vast amounts of lands west of the Appalachian Mountains claimed by some states as territories. The smaller states would not ratify the Constitution until the others gave up their claimed western territories for the mutual benefit of them all. This resulted in Article 4 of the Constitution, which is referred to as the Property Clause, not to be confused with the Fifth Amendment, which refers to private property. This is the Government Property Clause. It says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. So then, to me, that begs the question, has the government disposed of these lands? Or if they haven't disposed of them, have they disposed of some interest in these lands? Because they passed all these right-of-way laws, water right laws, various other kinds of statutes. And here's something else to keep in mind. We'll get to this a little later, but the Federal Land Policy Management Act specifically refers to land use rights. Not just right-of-ways or easements, but land use rights. And numerous times. Why would Congress include a phrase? They wouldn't, I'll tell you this now, but the question in your mind should be, why would they include a phrase that refers to land use rights if land use rights didn't exist? Because the courts have said Congress does not enact vain statutes. In other words, they don't just put, it may seem this way, but legally they don't just put language in the statutes that has no meaning. They don't just add language to that to make it more verbose. Does that make sense? But that is what the courts have said. So why would they talk about land use rights if no land use rights existed? That should be one question that begs in your mind. Well, the fact is land use rights did exist.